I'm letting the law clerks into the courtroom.
I'll be your tech guy.
Yeah, if you would.
Judge, may I open court?
Just let them adjust their podium.
Sorry about this. May have to be done manually. Okay, there you go. I apologize for being tiny, but if this works, at least you can see me now.
That's fine. Anne?
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1330, NGL Supply Wholesale, LLC, Petitioner versus Federal Energy Regulatory Commission and United States of America. Mr. Dre for the petitioner, Ms. Pasella for the respondent, Ms. Steckman for the intervener.
Good morning, counsel. Mr. Dre, please proceed when you're ready.
Good morning, and may it please the court. I'm Dominic Dre, and I represent NGL, the petitioner in this case. I'd like to reserve 2 minutes for rebuttal. This case tests the limits of how a pipeline operator can use its affiliate to restrict access. The Phillips companies have devised 3 ways to discriminate against their competitor, NGL, and the commission offers only post hoc justifications for accepting these tactics. First, the affiliates pretend that the interconnection facilities that serve no purpose other than transportation are akin to storage facilities. Second, Phillips Pipeline's pro-rationing policy effectively ensures that only P66 will be a regular shipper, and that is exactly what has happened. Third, P66 elevates form over substance to use a nominal exchange agreement to evade supervision of its affiliates' shipping transactions. The common thread in all of these is the strategic use of an affiliate to own an interconnection, to hold a monopoly and serve as gatekeeper over regular shipping, and to negotiate transportation apart from the pipeline.
Why isn't the commission's reference to TEPCO, its precedent, a response to most of the arguments you're making now?
Well, Your Honor, for a number of reasons, I actually quite love the TEPCO case because there the court explains, and I think this is particularly relevant for the interconnection, which is that last few feet of pipe between the Williams terminal and the beginning of the Phillips pipeline. There, the court explains that anything that is necessary or integral to the transportation function falls within FERC's jurisdiction. And that, by the way, is a fairly consistent interpretation of the statutory language at section 1.3 of the ICA, which lists a broad definition for transportation, including all service in connection with the receipt of the property transported.
Clearly, the commission has drawn a distinction between transportation and what's going on at these supply facilities, has it not?
Oh, yes, Your Honor. And
so it's applied it in this circumstance and previously noted that the fact that there's an affiliate relationship isn't dispositive. And furthermore, that your client made a business decision. And I really didn't see any answer to that.
Okay, well, I think there are 3 points in Your Honor's question there that I'll sort of respond to rather quickly. The first is, yes, they do draw a distinction for terminaling facilities, but the conduct in this case, what we're talking about is pipe that serves no purpose other than transportation. So it's not like storage or odorization that were at issue in TEPCO.
So if I hire a truck to bring propane to the transportation point, that truck is part of jurisdictional transportation?
No, Your Honor.
What's different here?
Well, for starters, that's not a common carrier. And that gets to the alternatives argument that I think is so prevalent, but actually a complete red herring in this case, which is that FERC routinely points to, and less so FERC in its order, by the way, and we should distinguish between these, more FERC, on appeal and interveners, of course, the Phillips companies, to the existence of alternatives. But there are always alternatives. You could, for that matter.
But the commission in its order refers to that specifically. And I didn't see you respond in any way, or your client respond in any way, in the sense of either saying, those are financially prohibitive alternatives, or, we don't have the necessary interconnection, or whatever. I just didn't see any response. Have I missed something?
Judge, I do think that you have missed that, because.
All right, where does your client say those are not alternatives available to it?
So they point to the commercial practicability in a number of places.
And what does that mean, commercial practicability?
So, for example, and this is bleeding more into the pro-rationing discussion, the Phillips companies at page 12 of their brief say things, and they said this in their answer below as well. It's the same argument.
I really want to know what your client said in response to FERC's reference to its view that this was a business determination by your client.
Oh, okay. So first of all, Your Honor, what we point out is that that's irrelevant, that you do not have to work around and explore other options when it's a common carrier, because there are always other options. We could just hire a truck to drive the propane all the way across these 3 states if we were so inclined. The ICA exists to force common carriage. That's the whole point of the ICA. Where you have affiliate transactions, you could very easily interpose. And frankly, if FERC and the Phillips companies were correct in this case, I would advise every pipeline company I have to insert an affiliate for the last few feet of pipe, which no one argues accomplishes anything other than transportation, and extract rents above the FERC-approved tariff. The ICA requires a common carrier to provide transportation service upon reasonable request. And the reason—
Let me ask you, counsel, and I may have missed this. I thought FERC's response was there any undue discrimination? And it said, well, you made a business judgment. In your terms, it wasn't commercially practicable. But it's not as though the blue line isn't open to all comers, and that P66 would accept propane delivered by these alternative means. I just didn't see that issue directly contested by you either before the commission or in your brief on appeal.
So again, I think part of the reason for that is that it's irrelevant whether or not there are other ways to work around. The question is whether—
But the question is undue discrimination, isn't it?
Yes, that's right, exactly. And so you cannot take part of your transportation function and opt it out of the FERC tariff and then demand a separate payment for that, or for that matter, assign to an affiliate a gateway function that makes them a monopolist on the east end of the pipeline to control access to whether or not anybody becomes a regular shipper.
If we were to affirm FERC's decision that this is not jurisdictional, the endpoint there, does that take out all the other issues, or do we still have to examine the discrimination with respect to the loyalty user as opposed to the new user?
Yes, bad news. The court will have to address all 3 of them. I don't think that they rise and fall on that single question, Your Honor. With that, I want to be mindful of time, so I'll reserve the balance here for rebuttal.
Okay, thank you, Mr. Dre. Ms. Pasella?
Good morning, Your Honors. Can you hear me?
Yes.
Thank you. So I think I'll start off with the proprietary interconnection. The commission's holding was that there are other ways to transport propane from the Williams terminal to the Blue Line. So what that means, is that the interconnection is not necessary or integral to move propane from Williams to the Blue Line, and therefore it's not for jurisdiction.
Counsel, could you respond directly to what we just heard Petitioner's counsel say in response to my questions?
I'm not sure I fully understood what he was saying, Your Honor. I'm sorry.
He said, first of all, there's no requirement where an affiliate is setting itself up basically as a monopolist for access, and that what FERC referred to as alternatives are commercially impracticable.
So what the commission's talking about regarding business decisions and alternatives is really, it's just alternatives from the exchange agreement, Your Honor. What the commission is talking about there is, if you look at the business decisions, the commission is talking about that it fails, NGL fails to achieve regular shipper status, that it results from its own business decisions not to obtain alternative propane supplies. And what it's talking about there is that they have never asked Phillips 66 to sell to them in the summer. This is a summer issue.
At this point, where in the order are you talking about?
So I'm talking about it's not set out in the order. What the commission says in the order is at JA 8, paragraph 20, where the commission makes the business decision point, but that's not the commission's fundamental holding. So the commission doesn't spend much time on that. The commission's fundamental holding is that nothing prevents a shipper that nominates volumes on the Blue Line in 12 consecutive months from becoming a regular shipper. And that's how the commission reviews this, because what the Interstate Commerce Act requires is that common carriers provide service to shippers that request service. And so nominations are the issue. You have to already be nominating before a pro-rationing policy takes effect, before the commission would consider whether a pro-rationing policy itself is unduly discriminatory.
Does it make any difference that the way the pipeline is operated, it goes north for half of the year and south for the other half of the year? And let's just suppose here that what NGL wants is to go north all the time.
It doesn't make any difference, because the point of pro-rationing policies are to honor shipper loyalty. So when a common carrier is required to take any reasonable request for service. And so what happens is sometimes there's just too much request for service. They can't take everybody. So pro-rationing policies are necessary and they're legitimate. And the historical pro-rationing, which is very common and long approved by the commission, allows the pipeline to promote shipper loyalty, so that they don't lose shippers who do ship on them, not just 6 months of the year, but 12 months of the year. And so that's what's occurring here. And here, NGL says that they can't ship during the summer because Phillips 66 won't sell to them. But the record not only doesn't support that, it refutes that. If you look at Phillips' answer at JA 237, they explain NGL has not asked Phillips 66 to sell propane to it at Wood River, which is on the east end of the Blue Line, in the summer. And then NGL answers that it stands by its assertion at JA 643. NGL stands by its assertion that it has requested to purchase propane supply from Phillips 66 at Wood River to no avail. In support of that, they submit Exhibit B. And I can't talk about Exhibit B. I apologize. I did not intend to talk about a sealed document, and I will not. I will just refer you to page 708. I won't tell you what it says, but I will mention that it is a winter date, not a summer date, these emails. So they submit 2 emails in support. Neither of these emails is dated in the summer. They're dated in the winter period. So there's no support for NGL's claim that Phillips 66 has refused to sell to them. And the record shows definitively that there's never been a request for service in the summer. and that Phillips 66 has said that they will sell to them. So the concern, so it really is a business decision of NGL not to ship in 12 months. They do have this alternative option of simply asking Phillips 66 to sell to them.
Can I ask you a question about the exchange agreement part of this, which I guess the commission addressed initially in its order, but it's the last issue raised in the briefing. So I take it that the way that this works conceptually is that the question is whether what's going on is just an exchange of product, which is non-jurisdictional, or whether there's also transportation along the pipeline, which would bring it within jurisdiction. That's at a high level of generality, effectively the distinction that
that's basically right, Your Honor. The question is whether the agreement provides just for an exchange of the product, or whether it requires that the product be transported on the pipeline, that there be transportation on a pipeline. And the commission's finding here is that there's no requirement, Phillips 66 does not have to transport the propane it receives from NGL at Conway on the blue line to effectuate the exchange. The agreement provides, if you look at Phillips' answer at 23 to 24, which is cited by the commission in the order at JA 3, paragraph 11 and note 7, it provides that during the winter months, NGL shall tender propane to Phillips 66 at Conway, and Phillips 66 shall tender an equal volume of propane at NGL's terminals in Jefferson City and East St. Louis. So there's no requirement that it be moved on a pipeline. And the fact, and the record also explains why there are these fees that some of the fees include pipeline transportation type rates. And the reason for that is because it's, as Phillips 66 explained, this is a typical way of doing things that commonly, there are fees included that are intended to equalize the value of the product at the exchange point, and these are simply that.
I guess that I don't have any particular reason to dispute any of that. It's just that the commission's order doesn't talk about that.
So what the commission does is it cites to Phillips' answer at 23, which is JA 253, and JA 253. And that's only a little bit of the paragraph that addresses this is on JA 253. It follows on to JA 254. And on JA 253 to 254 is the entire answer. Phillips 66 explains that it can sell the propane NGL tenders at Conway to a third party at Conway. It can have the propane NGL tenders transported to a destination other than NGL's terminals. It explains that then Phillips 66 can and does meet its obligation to tender propane to NGL terminals by sourcing propane from other origin points on the blue line or from other supply sources. And it further explains that this enables Phillips 66 to tender the volumes to NGL's terminals as soon as NGL tenders its volumes at Conway.
And that's what you're relying on in terms of the commission's order is it footnotes 6 and 7?
I'm relying on JA 3, paragraph 11 and note 7.
Note 7, okay, yeah.
Which is citing Phillips' answer at 23, which is really also 24 because it's that same paragraph. So the commission incorporated that answer into its order. And let's remember that what this court's case law says is you just have to be able to discern the commission's path. The commission does not have to say every single thing in its order. If it cites to something, that can be okay too.
Okay, let me make sure my colleagues don't have additional questions for you, Ms. Pacell. Thank you. We'll hear from Intervenors Counsel, Ms. Steckman.
Thank you, Your Honor. Good morning. I'm Britt Steckman on behalf of the interveners, and may it please the court. I'll address the interconnection mechanism if that would be helpful, or I'm happy to address any of the other issues as well. just to shed a little more color on this interconnection that P66 had constructed in 2018 at its own cost. So that interconnection is a direct connection, as you know, between the Williams terminal at Conway, Kansas, and the Blue Line. And for many years prior to the construction of that interconnection, shippers used a couple of other methods to get their product out of that large Williams storage facility and onto the Blue Line. They could do that either by going through the One Oak terminal or another interstate pipeline, which is called the Central Line. Mm-hmm. And both of those have direct connections to the Blue Line. And that worked fine. That worked fine for many years. But it did raise a logistical difficulty that was specific to P66, the shipper. And that's because P66 ships both propane as well as butane on the Blue Line. Butane is actually critical to the operations of P66's refineries, which sit on either end of the Blue Line. And P66 needs to have the ability to move that butane out of storage to its refineries whenever it needs to do so. And it needs to ensure that the butane would not be contaminated either by being mixed with propane or with lower quality butane. And so it would require just a lot of coordination on P66's part whenever they needed to get that product out of storage. And that's why in 2018, P66 chose to contract with Williams to have Williams, the storage provider, construct a line that directly connects the Williams terminal to the Blue Line. That ensures deliverability and quality for P66, which again is the shipper, not the pipeline operator. P66 later chose to expand the scope of that interconnection that it was already constructing to include propane movements as well. And again, this is all just for P66's operational purposes related to its movements of both propane and butane. So if P66 were to require another shipper, NGL, to use that line, it would essentially defeat the purposes for which P66 made that investment, which was to be able to quickly and reliably move whatever product it needed out of storage.
Well, counsel, I didn't understand that to be the nature of the answer. I thought the nature of the answer was, well, NGL never asked us, which the implication is that if it had, it wouldn't have said nope, just arbitrarily, but rather it would have said either no, because we don't have any space available for the time slot you want, or something like that, given a rational answer.
Well, Your Honor, there are two different issues here. The issue for which P66 said you never asked us, that's actually the issue of purchases from the Wood River refinery. That's that refinery that sits at the east end of the pipeline, and the interconnection is in Conway, Kansas. So NGL has raised these three separate issues on appeal, and the interconnection is issue one, and then the issue of whether P66 would sell to it at the Wood River refinery, I think that's issue number 2 or 3.
So issue number 1 at Conway, there's no space available?
Well, essentially P66 needs to have its proprietary interconnection available for its own use so that it can choose which products it's moving in and out of the pipeline between the pipelines.
So is that a yes to my question?
I apologize, Your Honor. I apologize. Could you repeat it? I'm sorry.
My question was, I thought the answer was they never asked us. And you said, no, that's as to the Wood. As to the Conway, P66 needs it for its own products. So
correct, Your Honor.
No space for anybody else.
Correct, Your Honor.
All right, so the answer is yes.
Yes, ma'am.
Okay. Let me make sure there's no additional questions from my colleagues for you, Ms. Steckman.
Yeah.
Thank you.
Thank you.
Mr. Dre, we'll give you your 2 minutes for rebuttal.
Okay. So good morning. A couple of responses there. First of all, I appreciate my friends on the other side clarifying the Conway versus East End distinction and the issue there. The Reese affidavit, which is under seal, but at pages 173 through 176, discusses at length how much we've tried to ship on the west end at the Conway. And as the court will see, NGL could fill the entire blue line and has proposed to do that over the course of several years. So the issue of not being a regular shipper is biting NGL on the west end because we can only ship 5% as a new shipper. So these are actually quite interconnected. To return to the pro-rationing topic briefly, the commission sort of relies on this idea and it puts blinders on itself in violation of Michigan versus EPA to say that if we say that something is based on who nominates, that we won't consider anything else, the practical possibility of nomination. And there's a fact issue around whether or not Phillips had in fact refused, and I suppose it would be P66 to keep my entities straight, whether P66 had refused to sell on the east end of the blue line. The record citation at 643 is dated in a winter month, but it is an attempt to purchase for the summer months, which is how one negotiates these kind of transactions. The complaint, this is at JA 17, asserts that that P66 refused, and there was never an evidentiary hearing in this case. I mean, one sort of, well, I guess there are two vexing features about this litigation. One is the lack of explanation and evidentiary hearing below, and the other pervasive issue is the affiliate nature of this transaction. And this court, just over the summer in Environmental Defense Fund versus FERC, explained that it would, A, not consider the so-called business decision justification that's at page 33 of the EDF opinion from this past June, which postdates the party's briefing in this case, and that it would look with higher scrutiny, that's a quote, the court would view with higher scrutiny affiliate transactions because there's no arm's length negotiation. And so in this case, you have an affiliate controlling who becomes a regular shipper, and look at page 12 again of the Phillips Company's brief, where they give themselves a generous carve out for when they're willing to sell on the east end. And then you have this sort of slick interposition before the Williams terminal on the other side. Last point, FERC does exert jurisdiction over the interconnection with the One Oak terminal on the west end. And there's no rational explanation for why they don't exercise jurisdiction over this interconnection, which is exclusively.
Did you make that comparison in your brief?
I beg your pardon?
Did you make that comparison in your brief between?
Yes, sir.
You do? Okay.
Yes, sir. I don't have a page number for you, but
That's okay. That's okay. But I don't have it in front of me anyway. So.
Thank you, Judge.
Okay, my colleagues have no further questions for you. Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 20-7078, Agudas Chasidei Chabad of United States versus Russian Federation et al., State Development Corporation, VEB.RF, formerly known as Vnesh Econom Bank Appellant. Mr. Lifshitz for the appellant, Mr. Lieberman for the appellees.
I just need one moment to get my file.
Hold on for just 1 second.
Thank you.
Good morning.
You're ready.
Good morning, and may it please the court. David Lifshitz for VEB, and I'd like to reserve 5 minutes for rebuttal. Within the meaning of the FSIA, VEB is an independent instrumentality of the Russian Federation entitled to sovereign immunity. Every court that has considered this question has held so. The district court below ignored its obligation to adjudicate VEB's sovereign immunity. Instead, it authorized a subpoena directed to VEB, apparently based on the finding of jurisdiction over the Russian Federation itself. In so doing, the district court erred in two ways. First, the district court failed to consider VEB's immunity, which requires immediate correction. This court's precedent is clear that VEB is entitled to have its immunity determined before it is forced to partake in U.S. litigation.
Partake in litigation is a rather broad term. Is there well, you're asked the question by the opposing briefs, is there really a third immunity, or do immunities only exist as to being a defendant in litigation or being attached, as opposed to simply being subpoenaed, as it were, or ordered as a witness?
Your Honor, Section 1604 provides immunity from the process of the district court. It does not draw a distinction between discovery.
What are the words that you're using there?
Just one moment.
Read it from the statute if you have it.
Of course. Subject to existing international agreements to which the United States is a party, at the time of enactment of this act, a foreign state shall be immune from the jurisdiction of the courts of the United States and of the states, except as provided in Section 1605. This court has held that in order to issue a subpoena, the district court must have jurisdiction over the matter. It did not have jurisdiction over VEB here. That is the Houston Business Journal case, Your Honor. Moreover, I would also point you to the Second Circuit decision in Peninsula and in Vera. And in Peninsula, the case was very much focused on third-party discovery from an agency and instrumentality of the Korean government.
Let me ask you, counsel, when your client filed a supplemental brief to its motion to quash, it raised an immunity defense, did it not?
It raised the immunity defense of the Russian Federation. Yes, Your Honor.
And so at the point, I'm just trying to understand. So VEB never raised its own immunity? That's what I'm trying to clarify here.
No, that's not true, Your Honor. VEB.
Well, where did it raise it?
Sure. At JA 25, VEB preserved its immunity
yes, it says not waiving any immunity or other defenses. And
right.
that's it.
But as Your Honor
that's not the same as raising an issue.
That's true, Your Honor. But as Your Honor held in Houston Business Journal, a district court must satisfy itself as to its own jurisdiction. The district court did not do so here. We thought that adjudication through the 1292 motion that we did file, very expressly raising VEB's immunity, and the district court—
But you just told me it didn't.
Well, in 1292, Your Honor, in our motion in 1292 filed in January of 2020, we specifically asserted that the district court lacked jurisdiction and over VEB, lacked subject matter jurisdiction over VEB, and asked the district court to review that finding and certify that finding for appeal. The district court ignored that argument. It's not that it decided it against us. There is no decision on VEB's immunity argument at all.
So
decision on, excuse me, go ahead.
Go ahead, no, please. Thank you. If on the 1292B, the district court didn't certify it for interlocutory review.
That's right, Your Honor.
If it doesn't certify it for interlocutory review, how do we have jurisdiction under 1292B? Because that's a necessary ingredient to our jurisdiction.
Of course, Your Honor. So I think this is an answer in three parts. First of all, this court always has subject matter, always has jurisdiction to review a district court's lack of subject matter jurisdiction. Second of all, in Briggs, Your Honor, this court established a framework, and it's a little bit confusing because the Briggs majority opinion on this issue is in the dissent. But if you look at it, in that case, this court explained that a immediate review of a 1292 denial maybe is appropriate in a small class of cases where the district court's decision effectively abrogates a litigant's immunity from having to participate in the legal process. In fact, Briggs uses that as an example, stating that a decision which has the effect of abrogating immunity, which protects a person from a trial under action as much as from an outcome on trial, is precisely the type of case where immediate review would be appropriate. And if you look at this court's decision in Papandreou, where it finds that sovereign immunity is precisely the type of immunity from trial and the attendant burdens of litigation, and not just a defense to liability on the merits. And going back to Judge Sentelle's question earlier, Papandreou is precisely a case that dealt with discovery rather than the merits, as I mentioned earlier, the Peninsula case in the Second Circuit. And finally, Your Honor, if you're
Briggs, there's some confusing things going on in Briggs because of the variation of the panelists and the different issues that different people addressed and the possibility of collateral order review. But apart from that, I'm not understanding how under the terms of the statute, we have jurisdiction when the district court just didn't certify under 1292B. That just seems to be under the terms of the statute, a necessary predicate to our jurisdiction to review the interlocutory order via that route. There might be other routes to review something, but under 1292B, the terms of the statute require certification by the district court.
That's right, Your Honor. We're not arguing for a review of the district court's discretion. We're arguing that order, which ignored VEB's immunity argument in toto, effectively abrogates VEB's immunity as an instrumentality of the Federation within the FSIA, and under this court's precedent in PNID, Briggs, and Papandreou, that should suffice to provide jurisdiction.
So could you take a collateral order appeal of the previous order?
I'm sorry, Your Honor.
Could you have taken a collateral order appeal of the previous order?
Yeah,
was
Your Honor, admittedly, the question was unclear when we were looking at it. Generally, discovery orders are not subject to collateral order review. It was only 6 months after we filed our 4 months, I guess, after we filed our 1292 order that this court decided PNID. And in PNID, it made clear for the first time that any order that effectively abrogates immunity is subject to collateral order review. That, of course, was a scheduling order. And we submitted a notice of supplemental authority on that point to the district court. Again, there was no answer. And following all of that, Your Honor, if you feel uncomfortable with simply reviewing the 1292 order, there is the avenue of mandamus, which we submit is satisfied here. There's no dispute that—
But it's hard to grant mandamus in a situation in which there was another route. And if the other route was a collateral order appeal of the December order, then mandamus would seemingly be off the table because that's one of the predicates to mandamus.
Well, Your Honor, we did seek we did seek review of the December order. We thought it through 1292. At that time, there was no clear avenue that
Did you file an appeal of it or an attempt to appeal of it?
I'm sorry, Your Honor, one more time.
Did you file in this court for review of that 1292 order?
Yes, we did. We filed in this court timely notice of appeal of the July order of the 1292 order. And to go back to
the December order, but not
the January.
Sorry, we did not. Yes, I apologize for the confusion. Yes, we did not seek immediate review of the December order in this court. We did not think we had the ability to do so because at the time it was a discovery order and it was not clear. So we believe 1292 required us to ask, we believe that at that moment we needed to seek certification. This court subsequently issued PNID, which identified an alternative route, which is the route that we saw. But if you put us back in the position in the position that we were in December, Your Honors, that wasn't clear. It certainly wasn't obvious. And so we did what we thought we needed to do to preserve to assert our rights and to challenge the district court's jurisdiction. But we were not sitting on our hands. We took every opportunity available to us along the process. And the fact remains that today, before this court, there is no adjudication.
Take every opportunity available to you because I'm not saying you necessarily, I'm not attributing anything to this. It's just that you had another opportunity available to you. And at the time you didn't believe that it was, but it turns out even you seem to concede that it turns out that it was available to you at the time.
I would submit, Your Honor, that P&ID was a significant shift at the time that it happened when you, for the first time, ruled in the context of an order that is not typically available. I would also note that this is an area of law which differs from some others. In Papandreou and McKesson, this court endorsed, and sovereigns routinely make seriatim motions before asserting immunity. So if the issue was that we needed to make a second motion to quash, we would gladly do that. We are not asking for anything more than having our immunity adjudicated by someone. We believe this court has the authority to do so on the record before it. It is, after all, a question of law.
Is there a time limit on filing a second motion to quash now?
I am not aware of one. Again, this is an area which has not come up before. So if the answer is that we go down below and we make a second motion to quash, that would be perfectly appropriate. We're concerned about the fact that if we do so, we would run into issues of sanctions. And this court has already identified that it would be inappropriate to sanction an agency or an instrumentality of a sovereign without immunity being first adjudicated.
Okay. You wanted to reserve some time for rebuttal, but let me make sure.
We reserve 5 minutes.
Let me make sure my colleagues don't have additional questions for you at this time. Okay. I'm sorry, Judge Sentelle, do you have a question?
Is it really fixed that your immunity is not derivative from the Russian sovereign? You understand what I'm saying? They
Yes,
have waived, if the Russian sovereign has waived or has been held to have waived, and I understand maybe some dispute about whether Chabad 1 was correct, but do you have an independent immunity if the sovereign from whom you derive your status has lost its immunity?
Yes, Your Honor. This, in order to exercise jurisdiction over us on the basis that Russia has lost its immunity, which is exactly what Chabad asks this court to do at 32, would require this court to ignore 4 decades of precedent from the Supreme Court and from this court. The precedent of Bonkak, McKesson, and other cases that we cite in our papers makes clear that our immunity has to be adjudicated on its own basis. It's not, quote unquote, derivative.
Where not only the immunity in question before, but the litigation in question. That is to say, again, you're not a party to litigation. This is a discovery process where that matter has come before us in spite of the immunity of the sovereign. Why didn't that take your immunity with it? You're not the Russian government.
Of course, Your Honor, but just like the fact that the Second Circuit held that it had immunity over Argentina in the EM case did not give a jurisdiction over the Argentinian Central Bank, or in Walter Fuller Aircraft, the fact that there was a jurisdiction over the Republic of the Philippines did not give a jurisdiction over the Commission. The jurisdiction over VEB has to be adjudicated as with respect to VEB, not the Federation itself. They're independent entities within the meaning of the Supreme Court's Bonkak decision, and we're not aware of any case anywhere in the United States that would endorse abrogating immunity of an instrumentality within the meaning of the FSIA because the immunity of the sovereign has been deemed to be pierced in any context, including the jurisdictional context. Including in the discovery context.
That's all.
Thank you, Mr. Lifshitz. We'll give you a little time for rebuttal. Mr. Lieberman, we'll hear from you now.
May it please the court. The first question is, as each of your honors questions make clear, is whether this court has jurisdiction to entertain the issues that VEB purports to raise on appeal. VEB could have filed an immediate appeal within 30 days from Judge Lambert's order denying the motion to quash. It chose not to do that. In response to the panel's questions, Mr. Lifshitz argued for the first time, it wasn't in his opening brief, it wasn't in his reply brief, that the reason that they did not file the notice of appeal is because they had some question as to whether or not an appeal at that point would have been appropriate. I think Mr. Lifshitz post hoc argument about that is inconsistent with his argument that for decades it has been known that the Foreign Sovereign Immunity Act provides immunity against discovery for third parties. So I don't know how he's going to balance those two. But in any event, motion to quash, no timely notice of appeal. There's no jurisdiction to hear the issues on the motion to quash. On 1292B, this court and other courts have been very clear.
Can I just ask you before we go to 1292B on the motion to quash? What if there's a subsequent motion? Can there be a subsequent motion to quash?
I think if there is a subsequent event which gives rise to new issues, they could file a motion to quash.
And then at that time, would that be reviewable under the collateral order doctrine?
Depending upon the nature of the dispute and the order, yes, I think it would be.
Okay.
But they couldn't just file another motion to quash now. They'd have to wait for something else to happen. Otherwise, the jurisdictional requirement of a notice of appeal within 30 days would be meaningless.
Well, I mean, the district court would have to issue an order.
Yes. But if they just filed a motion to quash saying, based on what's happened in the past, we're filing another motion to quash, that would not give rise to the right to bring a new appeal. But if something else happened in discovery, it was new and distinct, certainly they could file a motion.
Okay.
As to 1292B, as Your Honor correctly pointed out, the statute makes very clear that there is no jurisdiction for the Court of Appeals to entertain a 1292B appeal unless the district court judge certifies the issues for appeal, which Judge Lamberth declined to do here. Therefore, 1292B does not get you up. With respect to mandamus, again, as Your Honor's question makes clear, because there was an alternative route, mandamus is not available. And if there was any doubt about that question, this court dealt with that issue recently in the Lee Hospital case. In the Lee Hospital case, this court specifically said that because the appellants in that case could seek the relief they desire under Rule 60B4, they cannot obtain mandamus relief.
Let me ask you back on the question of the 1292B denial not being appealable. It makes a great deal of sense, but the question I have is, if you have an immunity case, and forget about the instrumentality, so suppose you have a very clear sovereign immunity case in which the sovereign has the right to be immune, not just from judgment, but from litigation, and they're denied, and they make the motion, and then they're denied that appealability under the 1292. Is there no way that the sovereign can then get review of the immunity it's being denied?
Well, I think a 1291 appeal would be appropriate in those circumstances, Your Honor. And of course, here we have a very different factual situation. First, VEB chose, for whatever reason, not to raise the issue of their own purported immunity in their motion to quash, as Mr. Lifshitz answers to Judge Rogers' questions made very clear. Not only that, they made
why does that matter for jurisdictional purposes? Because even if they didn't raise it,
yeah,
I think you acknowledge that they could have taken a 1291 appeal of the order denying the motion to quash.
Yes, that's absolutely true.
So the fact that they didn't raise it doesn't matter, because if they would have taken an appeal at that point under 1291, then we would have been obligated to address the jurisdictional issue. Is that not right?
You would, although under the applicable standard of reviewing an appeal from a motion to quash, you might take into account what arguments they made and did not make below, and what factual assertions they made. So, for example, below, they made factual assertions that were inconsistent with their argument now that they're an instrumentality. If you look at the joint appendix at pages 30 to 32, they said that VEB is not owned or controlled by the Federation defendants. It functions independently. And this is a direct quote from what VEB filed. VEB, quote, is further removed from being an instrumentality of the Russian state than Exim Bank is with respect to the US government. So their argument to the district court was actually contrary to their argument now that they're an instrumentality. So Your Honor is right. You certainly could consider the issue of immunity, but you would consider it through the lens of the appropriate standard of review in light of the arguments and facts that were presented to the district court.
Can I ask a follow-on to Judge Sentelle's question, which is, your answer is you can't take an appeal from 1292B, but you could have taken a 1291 appeal from the original order.
Yeah.
And am I understanding it correctly that what happened here is there's an original order in December, and then there's a 1292B motion to certify that order for interlocutory appeal?
Well, yeah, I've read the notice of appeal, which is at the joint appendix at 502.505 a whole bunch of times, and I can't quite figure out what they're appealing.
But the 1292B certification was in the district court, not before us. The motion for 1292B certification in the district court was to certify the December order for interlocutory appeal.
Either that or to certify the denial of the 1292B motion itself. It's not really clear from the notice of appeal, but in either event, as a 1292B motion, the district court has to certify, otherwise this court doesn't have jurisdiction to entertain the 1292B appeal. So there are three routes up, I would submit. 1291, which is blocked because they didn't file within 30 days. 1292B, which is blocked because the district court didn't certify. And mandamus, because as Your Honor pointed out, there were other routes available, like 1291, which they chose not to
Didn't
take
do.
advantage of.
Okay. Let's see if my colleagues have further questions for you,
Nothing.
Mr. Lieberman.
Right. In that case, I have nothing further, Your Honor.
Thank you, counsel. Mr. Lifshitz, we'll give you 3 minutes. I think we used up most of your time, but we'll give you 3 minutes back for rebuttal.
Thank you, Your Honor. 4 quick points. First of all, sovereign immunity has never been held to be a use it or lose it device, which is what Mr. Lieberman is suggesting. When he says that something new would have to come up, what he's effectively saying is VEB has been ordered to comply with the subpoena. There would have to be a new order that would be appealable. That new order would be an order for sanctions. VEB would have to accept that it would be sanctioned in order and held in contempt in order to exercise its sovereign immunity. Papandreou squarely rejects that outcome, and the Kellogg mandamus case rejects similarly that outcome in the context of privileged documents. That's point 1. Point 2, our appeal of the July order is a 1291 appeal of the abrogation of our sovereign immunity that was clearly done. There is no authority and no case law anywhere in the United States, and Mr. Lieberman has identified none, that would permit a sovereign who has asserted immunity to have that question not be determined and have to comply and partake in the litigation. And it is all the more odious here because it is a third-party subpoena. So it's not even a case of where Mr. Lieberman suggests that we did anything wrong. It is a case where we're being sucked into a process to which we are not a party and ordered to bear that burden. Finally, sorry, Your Honors, point 3, on the question about owned and controlled and the representations to the district court. From the second paragraph of the preliminary statement, VEB argued that it was a duly created instrumentality of a foreign state. This is a JA 24. The point that was made is where Mr. Lieberman is reading is that just because we're an instrumentality does not mean that we are an alter ego. This court's finding in Transamerica makes the point very clear. An alter ego finding, it requires of showing that control that substantially exceeds the normal supervisory control. That is this court's finding in Transamerica and in McKesson. And finally, Your Honor, point number 4, there is no question of immunity there is no question of an applicable exception to immunity because Mr. Lieberman never once identified an exception. So here you would have a district court acting against VEB without jurisdiction. This court's jurisprudence prohibits that in Houston Business Journal and in Papandreou. There's no authority for that outcome. And finally, if I may, just one final point, Your Honors, in the briefing, there was lots of attention focused on NML and why NML would potentially permit Mr. Lieberman's subpoena. That, for two reasons, does not work. One is in NML, nobody was asserting, the subpoena targets were not themselves asserting immunity. And two, NML is a 1609 case. We are asserting immunity under 1604. It's entirely different, Your Honors.
Okay, thank you, Mr. Lifshitz. Thank you, Mr. Lieberman. We'll take this case under submission.
Don't go away.
Case number 20-7080, Agudas Chasidei Chabad of United States, a nonprofit religious corporation versus Russian Federation, a foreign state et al., 10X USA Incorporated, appellant. Ms. Konecki for the appellant, standing and jurisdictional finality. Mr. Riesenberg for the appellant, injunction, sanctions, and interpretation of 1605A3. Mr. Lieberman for the appellees.
Morning, counsel. Ms. Konecki, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. I'm here on behalf of 10X USA or 10M, a third party recipient of a post-judgment subpoena and the Rule 60B movement below. In 2010, the district court entered a default judgment against the Russian defendants that found jurisdiction under the FSIA section 1605A3 for Chabad's claims. This decision was wrong, at a minimum with respect to the claims against the Russian Federation. Because the property at issue in the dispute is located outside the United States, there was no basis for subject matter jurisdiction over Chabad's claims as to the Russian Federation, and the default judgment as to the Russian Federation was therefore void. Because that decision was void, the injunction was void, the sanctions were void, and thus the subpoena served on my client 10M to begin execution of the sanctions is also void. Chabad's subpoena is premised on the allegation that 10M, a Maryland company in the nuclear energy sector, possesses assets, quote, of the Russian Federation. Chabad specifically even seeks information about 10M's own assets on the purported premise that 10M is the alter ego of the Russian Federation. Now, 10M strongly denies this, but that is the asserted basis for the relevance of the subpoena.
I thought it had alternative theories in its subpoena, one of which was alter ego. So it wanted to know what assets 10M had, and then what its relationship was as well.
Right, on the purported basis that 10M is connected as the alter ego of the Russian Federation. The subpoena doesn't just, it's not like an information subpoena of, say, a bank asking about information about Russia. The information the subpoena is seeking is about 10M and 10M's assets, 10M's commercial activities, 10M's communications with its parent companies, all the way up to the Russian Federation.
What you're arguing about in this part of the case, if the judgment in Chabad 1 is upheld by us, doesn't everything you're arguing go away then? Because the steps you took each depend upon doing away with that final judgment. Well, or do I misunderstand?
With all due respect, Your Honor, just to clarify, the 2006 district court opinion and then the 2008 decision of this court that affirmed in part and reversed in part was neither were a final judgment. It was a granting in part and denying in part motion to dismiss, and then the Court of Appeals reversed on some grounds. That decision, neither of those decisions established with any sort of finality jurisdiction over the Russian Federation, and we know this for several reasons. First, this court held in the DeShepel case that the 2008 decision.
Leave out the other cases, just dealing with that case at the moment.
Okay, sure.
What was unfinal about the decision with respect to the immunity of the Federation?
A number of aspects, Your Honor. And we know this by looking at the 2010 default judgment entered by the district court. In that decision, the court addressed all of the jurisdictional elements, again, in part because in 2006, it had only applied the non-frivolous test. And then also it addressed new jurisdictional elements that hadn't been addressed at all in 2006. For example, whether the alleged agency and instrumentalities were in fact agencies or instrumentalities. That was a critical jurisdictional element that was completely unaddressed in 2006. And the district court found that it needed to still get to that question. So there was nothing about jurisdiction in 2006 or in 2008 that was final and established. That decision was only made with respect to any notion of finality in 2010 in the default context. And because that decision was a default, the Russian defendants were not participating. The Chabad had clearly sought a motion for entry of a default judgment, and that is what the court granted. This case then falls squarely into the Bell Helicopter and Practical Concepts and Sudan v. Owens line of jurisdictional review.
So the question in this case, the question before us right now concerns whether 60B is the right way to bring this up, because even if you're right, let's just for purposes of this, let's just assume that you're right, that there's a jurisdictional objection that could be made. That there was an opportunity to do that, as you point out in your briefing, in your own briefing, by filing a motion to quash. That didn't happen. And so then there was a 60B motion. And the question is, are you situated to bring the 60B motion? Because if you're not,
right,
then I think you would agree that you don't have a route now. You have to be a party that can actually raise the 60B. And under 60B, just everything about the terms of the rule seems to contemplate that it's a party to the underlying judgment. Yeah, now I'm not disputing that the underlying judgment has some effect on you, because I get that it's a consequence of the underlying judgment that you're then within the range of a subpoena, but you're not actually the party. And it's difficult to see you as a legal representative, at least in the normal way we think about legal representatives, which is a trustee or somebody who's actually standing in the shoes of the party. And then if I thought that that's all 60B covered, then I'm not sure I see how you have authority to bring this before the district court and before us. And in service of the proposition that I do, that may be all that the rule covers, when I look at the rule, it talks about the parties in a number of situations. For example, 60B3 talks about whether there's fraud, misrepresentation, or misconduct by an opposing party, which talks about whether the party who supposedly considered the fraud is opposed to the party. It talks about newly discovered evidence, which by nature refers to actions of the party to the underlying judgment. And then the text, which you've engaged on, may relieve a party or its legal representative, seems to make it an uphill battle to say that a non-party such as yourself can rely on 60B.
At least 3 points on that, Your Honor. So first, as to whether that was raised in our motion to quash, the district court recognized that jurisdictional issues were raised in our motion to quash. That's at JA 798, and said that TENM had been raising jurisdictional issues. And so when TENM sought certification of the denial of its motion to quash under 1292B, that court did engage on the exact jurisdictional arguments that we sought to certify for appeal, specifically this issue of whether Russia satisfied 1605A3, the B1 prong, if you will. Second, what that motion to quash was denied, and it was referred to earlier today. The alternative is to wait for sanctions, which was something that we could not do, and those sanctions provide further reason why TENM is strongly affected by the judgment, the threat of such sanctions. And then three, turning to the text of Rule 60B.
On the motion to quash, if there's a jurisdictional objection to the motion to quash on the basis that there's not subject matter jurisdiction in the underlying suit, and that's rejected, then that's something that can be appealed. That's presumably something that could be appealed.
Right, and we sought certification of.
No, not certification. I mean, are you talking about 1292B certification?
Yes.
Right, but
when the motion to quash was denied, our understanding was that if that decision was not certified for appeal, then we needed to wait until there was a decision compelling.
And your understanding was based on what?
Well, I would have to get back to you on that.
I mean, that's the issue in the other case. And if we thought that collateral order review is available when a jurisdictional objection to a motion to quash is denied, then that's a route to take. Here, that didn't happen. I don't even know that it was raised in the motion to quash, but in any event, right now, all we have before us is the 60B route.
Yeah.
And the 60B route, putting aside the motion to quash, requires that the party who brings it be either a party or a legal representative.
Right. So we were not trying to seek a collateral order appeal the way that DEB was, in that we were not asserting Tenham's own immunity. And so that was why we didn't think that Tenham had a direct appeal of the denial of the motion to quash. But I do want to move on to the text of Rule 60B to get to that part of your question. The rule itself is silent on who is the proper movant. And the courts, however, have held that a legal representative includes any party alleged to be in privity with the judgment debtor who would be relieved. Chabad's allegations with respect to Tenham is exactly that there is some sort of a privity relationship. That's the fundamental basis of relevance of its subpoena. And while Tenham strongly denies that, we've pointed to cases that show that when evaluating standing, including in the context of a issue and claim preclusion and in the context of a non-party, third-party intervener defendant.
Who would be relieved under your theory? The text of the rule says the court may relieve a party or its legal representative from a final judgment order. Who would be relieved?
On Chabad's allegation, certainly Tenham would be relieved because Tenham is alleged to be the alter ego. And so therefore it would
not on the allegations, because I think the allegations, I understand your point about the allegations. The allegations just could equally cut in the other direction. Two, if you flip it, it's a little bit difficult to attach, at least in my mind, too much significance to that because either side could make use of it.
Well, Tenham is the party that has been dragged in and is attempting to assert defenses to be relieved of compliance with the subpoena. So the opponent's allegations, just as in the case of a third-party intervener defendant movement, would you rely on the record that there is and the allegations from the opposing party. Obviously, also the Russian Federation would be relieved from the judgment, but because Russia would be relieved from the judgment and Tenham's only connection, the only relevance to the case at all is Tenham's alleged relationship to Russia. There's no alleged relationship to the other parties. So if
Russia needs to be relieved from the judgment, Russia can seek 60B relief, but it hasn't. And so
yeah,
it's you have to support the notion that you can bring the 60B relief.
Oh, right. Beyond the privity, I'd just like to talk briefly about
privity. Privity is something more than simply being related in some fashion. Wouldn't privity require something close to being able to step into the shoes, like the legal representative normally means?
Right, and that includes an alter ego. The only reason why Tenham's assets could possibly be relevant in the suit is because Chabad is pursuing information about those assets in an attempt to, with the purpose of executing the judgment against Tenham, not against Russian assets that Tenham holds in its possession, but Tenham's own assets.
Well, they're not attempting to execute against them at this point, are they? They're simply trying to find out what's there, with the possibility that they may turn out to be traceable to Russia. What?
Well, that's, with all due respect, that's not what the subpoena is seeking. The subpoena is seeking information about what Tenham possesses as to TENM's own assets, TENM's commercial activities, TENM's relationship with its own board of directors, its own commercial activities, its own activities in the United States.
Well, you're not bringing anything concerning the breadth of the subpoena. That would be a matter of a motion to quash, I suppose. But you're not talking about the breadth of the subpoena. You're trying to set aside a judgment here.
Right. And we say when you look at the record as a whole, the only way that there is relevance, which the district court has already held when it denied our motion to quash, the only basis for relevance of this broad subpoena is that TENM is alleged, it's on the allegation that TENM is the alter ego. If TENM is not alleged to be the alter ego.
You understand we start with a presumption of finality on jurisdiction from a judgment, and you're moving to set one aside. That's a heck of a burden, isn't it? You have.
Well, with respect to 60B4, the issue is not discretionary. If the judgment is void, then this court is without subject matter jurisdiction. And we would say that we would submit that this court is without subject matter jurisdiction to even reach the 60B standing, because the court must assure itself of subject matter jurisdiction. In this case, there is no subject matter jurisdiction with respect to.
I don't understand that point, that we're without jurisdiction even to decide whether a party can bring a 60B motion. That means that, wouldn't that mean that any party in the world could bring a 60B motion, even if they have no relation whatsoever to the underlying suit? But then a court would have to decide the merits of the 60B motion without deciding whether the party could bring it? Here,
TENM has no doubt Article 3. We were subpoenaed into the case. There is an allegation that TENM has to, so the process has been served. TENM has can satisfy the Article 3 standing, and in fact, post-judgment subpoena recipients, there's no doubt, can raise subject matter jurisdiction. So the notion that this court has to address subject matter jurisdiction should not be controversial. When a subpoena recipient raises subject matter jurisdiction, the court must address it.
The notion that a third party can come in years later and attack the validity under the motion to set aside is the 60B motion is at least controversial.
We understand it's not a frequent occurrence, but there's no doubt in this case that TENM can raise the argument that there is no subject matter jurisdiction. That is the Vera case.
If you can bring the case at all, perhaps you could, but the question we're raising is whether you can bring a 60B motion on the basis that you have here.
Right, and we think we can satisfy the standing for the privity argument. And then the other point, which I wanted to add, is that TENM is strongly affected by the judgment. I point out, in a very unique circumstance here, the subpoena is targeting TENM's assets, but there's no allegation that TENM could ever satisfy the injunction. This is a very unique circumstance. So that those sanctions, those $50,000 a day sanctions, will just continue to add up, targeting TENM's assets, but TENM has no way to satisfy the injunction. That is a unique one-off circumstance in which TENM is strongly affected.
For my purposes, I don't doubt that TENM is affected. Of course you're affected because the subpoena is directed against you as a consequence of the previous judgment. The question is whether your jurisdictional objection is properly asserted by Rule 60B, as opposed to via motion to quash, which you yourself in your briefing point out as a route. And I think that's the question that's before us under Rule 60B. Let me make sure that my colleagues don't have additional questions for you on these questions that you have, because I know your colleague on your same side still has an argument to make on some other issues. Okay, then why don't we hear from Mr. Riesenberg for now, and we'll give whichever one of you is going to take it a little bit of time for rebuttal.
Thank you, Your Honor.
Mr. Riesenberg.
May it please the court. We now turn to the injunction and the contempt sanctions pursuant to which TENM has been subpoenaed in relation to, quote, TENM's own assets, end quote. And then again, that's from the transcript. That's a statement by opposing counsel. So the US government has repeatedly described the remedies in this case, the injunction and the contempt sanctions, as, quote, entirely without precedent internationally, end quote, including at page 141 of the joint appendix. Neither Chabad nor the district court have ever identified any prior case by any court anywhere in the world, including in the United States, but nowhere else in the world where any court has imposed an extraterritorial turnover order against a foreign sovereign state. It is entirely anomalous. This unprecedented exercise of judicial power is literally, quote, an extraordinary circumstance, end quote, which would justify TENM's request for relief under 60B. The district court's orders should be vacated, therefore, including because they are contrary to the Foreign Sovereign Immunities Act, including the comprehensive scheme for addressing the property of foreign sovereign states, and the public interest, which is a requirement of any injunctive order, whether it's a permanent injunction or a preliminary injunction. The district court, in its 2010 order, entirely skipped consideration of the public interest in violation of its statutory duty under 28 USC 1608E to evaluate Chabad's, quote, right to relief. For all these reasons, both the injunctive order and the sanctions should be vacated, as well as all the subpoenas attempting to seek information pursuant thereto. So I'll first start by looking at the statutory aspect, meaning the interpretation of 1609 and 1610. Now, the US government at page 135 of the Joint Appendix draws our attention to the pre-enactment history of the Foreign Sovereign Immunities Act. Now, prior to the FSIA, the property of a foreign state was immune from execution everywhere in the world without geographical limitation.
Are you referencing the green brief?
Meaning Mr. Feldman's amicus brief,
Yes.
Judge Rogers, just to clarify?
Yes, as opposed to comments that were submitted by the United States in the district court at some point, and it's not clear to me what remains.
I'm referring to the statements of interest filed at page 135.
Right, but it hasn't filed an amicus brief, correct? And at some point, circumstances changed.
Well, this position that the United States government has taken in this case has been consistent across presidential administrations.
So I wasn't suggesting an administration change made a difference. I think circumstances have changed given what the district court has done.
Well, most recently, the U.S. government maintained its consistent position in December of 2019. We're not aware of any change in position. It is certainly not too late for this court to ask the U.S. government's views. That's something that this court has discretion to do, and 10M would have no objection whatsoever. In addition,
you have not requested that we do so. That I noted in your brief. All right, but in any event, your position is the United States thinks what? Foreign policy would be better off if this case stopped.
Well, the U.S. government would not be subject to a $135 million contempt sanctions order by a foreign court, and the U.S. government's arguments in foreign court would not be undermined in any of the, going by the numbers in the Helmerich decision by the Supreme Court.
So the answer to my question is yes.
Very much, yes. It's a strong yes, Judge Rogers. The U.S. government needs to defend against the orders of foreign courts in 1,000 cases at any given time before 100 courts in the world, and undermining the U.S. government's defenses with respect to injunctive orders and contempt sanctions is strongly contrary to foreign policy. That is a public interest issue, and the district court gave it short shrift when it ordered injunctive relief in this case.
Of course, that's different from not considering the matter.
It's improperly weighing the factors, which is frequently the way this district court has described abuse of discretion. Also, I want to distinguish between the district court's discussion of public interest in 2015, when the contempt sanctions were issued, and the 2010 order, where the district court did not discuss any issues of merits or remedies or the public interest aspect of the injunction whatsoever. There is not one word in the 2010 order addressing the public interest as required for injunctive relief. But this is the issue of the public interest, Judge Rogers, and that's only one of the issues that we're raising today. We're of course also pointing out the violations of the Foreign Sovereign Immunities Act, particularly the comprehensive statutory scheme, which under 1609(10) and 1610 abrogates foreign sovereigns' execution immunity only with respect to property in the United States. There is no abrogation of the immunity to which property is entitled outside the United States. And that's not just a diplomatic nicety, but a judicially enforceable norm, as the case law from before the FSIA shows very clearly. For example, I would point out the Dexter case at 43 F. 2nd 705. And then one final point before I reserve the remainder of our time for rebuttal or await any of your other questions. 1606, 28 USC 1606 is the pillar of the district court's conclusions, the pillar of Chabad's argument. That's where they say the power to order extraterritorial injunctions comes from. 1606 doesn't refer to remedies at all. It says that a foreign state shall be, quote, liable to the same extent as a private party. That is not a clear textual discussion of remedies whatsoever, and to apply that to justify extraterritorial injunctions, which have never occurred in the history of this country or any other, would be a violation of the canon against the extraterritorial application of law, which the Supreme Court emphasized in Kiobel, Morrison, RJR Nabisco, and numerous cases.
You may well be correct as to the merits of your cause, but doesn't it go back still to the issue that your colleague argued as to whether 60B is available to you, and therefore this appeal is available?
It certainly, yes, for these arguments, there is no question we would need standing. But
it's not exactly the same as traditional Article 3 standing. It's a finality of judgment issue.
Well, Judge Sentelle, I would draw your attention to the Second Circuit's decision in Grace, which was also a case involving a final judgment. So all of the presumptions that you've described would also be applicable to the Second Circuit's decision in Grace. The reason why the movement in that case had standing was because the opposing party's strategy was, quote, to collect money from the movement, end quote. On that basis, the Second Circuit said general principles of standing make this motion under Rule 60B appropriate. In this case, Chabad is trying to collect money from 10M. We're not at that.
Let me just be clear about one thing. I mean, I know you say the case isn't relevant at all, but at least there is a distinction here between trying to find out what assets VEB has and whether there is any authority to attach those assets. And the latter has not happened yet.
It hasn't happened, Judge Rogers, but standing is almost always evaluated based on the allegations at the outset of a lawsuit.
Well, there's where you're hurting yourself, because the district court said, you know, it couldn't order the type of relief you want, all right, because it would have no authority to do so under Rule 60B. And to that extent, applying sort of a statutory standing analysis, the third prong of standing would drop out.
I just want to quote the district court, Judge Rogers.
I'm quoting the district court.
Then understood. Just to supplement that quote, the district court said that there was no serious argument that Chabad stands in the There is no serious argument that 10M stands in the shoes of the Russian Federation. We found that, quote, remarkable because that is precisely Chabad's argument. Whether it's serious or not, Chabad says that we do stand in the shoes of the Russian Federation. That's why they're trying to pierce our veil. That's what they said on the transcript during oral argument to the district judge. And that is their argument, and that should be sufficient to give us standing to provide any legal arguments that correspond to their theory of the case, including under Rule 60B. And we'll reserve the remainder of our time for rebuttal unless there are further questions.
Having no further questions, thank you. Mr. Riesenberg, we'll give you a little bit of time for rebuttal. Mr. Lieberman, we'll hear from you now.
May it please the court, good morning again. I'm going to try to address the issues raised by TNM in the following fashion, subject, of course, to the order in which the court wishes to go into these issues. First, I'd like to discuss the 60B issue. Then I'd like to go into the jurisdictional finality issue, which has been raised by several members of the panel. And then I'd like to turn to some of the merits issues. But first, I do want to correct one point that was made by Mr. Riesenberg or his colleague in response to Judge Rogers' question. There are two theories that underlay the subpoena to TNM. One was the question of whether or not TNM was an alter ego of the Russian Federation. And the second was whether TNM holds assets of the Russian Federation, which could potentially be subject to execution, that is Russian-owned property. Now, starting with Rule 60B, we start obviously with the language of the statute, a party or its legal representative. I don't think there's a serious question that TNM is not a legal representative of Russia, even though in this lawsuit, it seems to be that what it's trying to do is to get a vacator of the actual ruling against Russia. So, but they're not a legal representative of Russia. Under Rule 60B, the language of Rule 60B, as Judge Lamberth pointed out, they do not have the right to challenge the underlying judgment. They haven't been able to cite any cases in which an entity that was not a third party that was a recipient of discovery, they challenged the validity of an underlying judgment. They cite two cases, Vera versus the Republic of Cuba. That wasn't a Rule 60B case, but it was also a case where there was a default judgment against Cuba. Cuba never appeared at all. Cuba followed the practical concepts option 2 scenario that was sketched out by Justice Ginsburg and her decision in practical concepts. The other case that they cite, the only other case, is this Housing Business Journal versus Office of the Comptroller case. That was also not a Rule 60B decision. It was a pending lawsuit where there was a subpoena to a third party, which was permitted to challenge the district court's subject matter jurisdiction. So they've cited no Rule 60B cases where they should be considered a representative. And as the chief judge's question about relying on pleadings and positions the parties take with respect to the availability of 60B relief made clear, that's a two-edged sword. If TNM is taken at its word that it should be considered a representative or a privy of Russia, then under principles of issue and judgment preclusion, they are stopped under res judicata, as well as jurisdictional finality. They would be precluded under principles of res judicata from challenging the underlying judgment. Let's recall here, this is a case in which Russia appeared, litigated for several years, lost in part and won in part on sovereign immunity in the district court, took an appeal, and on appeal, the portion that it had lost below was reversed. That's with respect to the portion that it had lost below was affirmed. That's with respect to the archive. The portion that it had won below with respect to the library was reversed on sovereign immunity issues. It went back to the district court. It continued to participate in the litigation for a year. When faced with discovery to which it needed to respond, it then withdrew. So this is a practical concepts option 1 case. Russia appeared, it fought on jurisdiction, it lost. It's a final judgment. So just on res judicata, if they are a representative, which they would need to argue to get up under 60B, then they lose under res judicata. If they're not a
let's just say for argument purposes, and I'm not saying that I necessarily agree with this or disagree with this, but let's just say for argument purposes that we accept your position that Tenem cannot bring the 60B motion because it's not a party or legal representative.
Right.
Let's just also say, and I know you'll resist this, but just bear with me. Let's just also say that they're right about the appropriate reading of the statute and the under of 1605A3, and therefore there wasn't jurisdiction to issue the underlying default judgment. What are they supposed to do?
Okay. So I am so happy you asked that question, Robert, because it leads right into the question of jurisdictional finality. I want to put aside for a second, I would like to discuss this if the court is interested in the issue, as to whether this court in its Chabad decision in 2008 properly interpreted section 1605A3. But I don't want to deal with that right at the moment. Let's assume, pursuant to your Honor's question, that this court follows the 4 subsequent decisions of the DC Circuit and says the Chabad court got it wrong. We dispute that, and I'd like to get to that point, but I'm going to answer your Honor's question.
Yeah.
So there are two separate questions. One is this court's decision in Chabad one that was sufficiently articulated and described?
Well, can I just ask you just to get a quick answer at least on one part of it, which is there anything they could do?
No.
You think there's nothing they can do? So even if the DeCepel reading of 16A5A3 is taken to be correct, I know you don't think it's correct, but for our purposes, it's the precedent that's on point at this juncture in time. Then the underlying judgment was issued without subject matter jurisdiction. And Tenem has never had an opportunity to make that argument because it wasn't ever in the initial case. That was Russia in the initial case. So a party that was never in the initial case and is now totally affected by the judgment, your view is that there's nothing they can do about it.
No, nothing they can do may be too strong because, for example, there are lots of types of property that are immune under the statute from attachment. There are all sorts of arguments that they can make that they're not an alter ego of Russia. If they win on not being an alter ego of Russia.
There's nothing they can do to take on the existence of jurisdiction to issue the underlying judgment that then begets your efforts to obtain relief against them.
That's correct, and let me explain exactly why.
And what about the doctrine that says that you can defend against a subpoena? You can quash a subpoena based on the lack of subject matter jurisdiction to issue the underlying judgment.
Right. So this court in Chabad, and I don't think there's any doubt about this. If you look at the DeCespel majority opinion, the majority opinion does not dispute that the DC Circuit in Chabad made a decision that the Russian Federation was not immune with respect to either the archive or the library. Mm-hmm. The issue in DeCespel was whether or not the decision was articulated with sufficient expansiveness that it should be entitled to precedential effect in the circuit. But the decision was made. It went back down. When it went back down, the district court made the appropriate findings to enter a final judgment. At that point, Russia had withdrawn, but they had decided to exercise practical concepts. Option 1, they fought on the issue. That judgment is final with respect to sovereign immunity for purposes of this case.
So suppose that in DeCepel, the cert petition was granted and the Supreme Court in DeCepel agrees with the view espoused by the United States in DeCepel in its brief, which is that the DeCepel view, our court's view of 1605A3 in DeCepel was correct. So now, then we know that the Supreme Court would have a precedent, just hypothetically, the Supreme Court would have a precedent that says that the way Chabad 1 looked at it turns out to have been incorrect. You'd still say that even though the Supreme Court precedent says that the jurisdictional basis of Chabad 1 was incorrect, that this party, Tenem, who has never had an opportunity to litigate that, would be out of luck.
That's absolutely correct. And it's the Supreme Court's decision in Federated Department Stores upon which I would be relying. And also this court's decision in GSS Group versus Liberia, both of which are discussed in our brief. In GSS Group versus Liberia, this court, a 2016 decision, said once an issue is raised and determined, it is the entire issue that is precluded, not just the particular arguments raised in support of it in the first case. And in Federated Department Stores, the Supreme Court said on jurisdictional finality, this is true even if the judgment, quote, may have been wrong or rested on a legal principle subsequently overturned in another case. So even if the law changes, you've got jurisdictional finality in the Chabad case regarding sovereign immunity with respect to the Russian Federation. Now, there are lots of other issues that TENM could challenge on. For example, statutorily exempt property, are they the alter ego or not? But if they are the alter ego, right, and this decision has been determined against the Russian Federation, they are bound by that. They are stuck. And it makes good sense that that would be the case, because in this case, Your Honor, we have 5 or 6 or 7 subpoenas out to different entities, including, U.S. banks that are holding Russian Federation assets. If every time we seek to enforce a subpoena, a non-party gets to come in and really relitigate the question that this court decided back in 2008, we would have chaos. And that's exactly why we have the jurisdictional finality doctrine. I hope that answer was clear and unambiguous enough, but I don't think TENM can challenge this issue. I don't think the Russian Federation can challenge this issue. I don't think anybody else can challenge this issue. In the Chabad case, it has been decided for this case. And going back to Rule 60B, we've got to go by the language of that rule. The language is clear. They're not the party. They're not a representative. They make the argument about strongly affected. That strongly affected rule has never been applied in this circuit. There is one decision by a district court on the strongly affected doctrine in this circuit, and the district court rejected strongly affected. And strongly affected came from the Grace case. And as Judge Lamberth pointed out below, and as many other courts have pointed out, including the Grace case itself, that was an exceedingly narrow exception to a well-established rule. And it was there to prevent a fraud perpetrated on the court to settle a third party with a judgment debt. That's what happened in Grace. And that's why the Second Circuit was so careful to say this was a very narrow exception. It cannot possibly be that TENM is seriously arguing that when Chabad brought this lawsuit to get back books that were first taken in 1917, that it's been fighting for 100 years to get these books back, that the reason it brought that lawsuit, the reason it brought the lawsuit and went to the district court and the DC Circuit on the sovereign immunity issue was to somehow stick TENM 12 years later. That's just not a credible argument. So they have no mechanism to challenge this under 60B. On jurisdictional finality, again, I think even if you were to decide in this case, and now I'd like to turn to the merits of the 1605A3 issue, if I may, Your Honor. But even if you would decide that you weren't going to revisit the Cesspool or the Simon case, jurisdictional finality doesn't allow for the judgment against the Russian Federation to be challenged in this case. And again, that's practical concepts. The law is, I would submit, very, very clear on that. So let me turn to the question of whether or not the Chabad decision is one that this court needs to follow, or alternatively, whether this is an issue as to which the court might want to refer this matter to an en banc panel.
Are you sure you want to get into that?
Well, let me start with this, Your Honor. First, Judge Lamberth wrote an extraordinarily clear and elegant 54-page decision explaining precisely why he believes that the DC Circuit is bound by the DC Circuit's decision in Chabad.
Right. And then we issued a decision in DeSapple that reached the conclusion that it did, and that's precedent in our court. Yeah. Whether you agree with it or not, and I understand that there are arguments in both directions.
Right.
That's a precedent in our court on what happens with the Chabad result going forward.
I understand that unless this court issues a new decision with an Irons footnote, or
we'd have to go on. The full court would have to do something with it, either by taking the issue on bank or by issuing an Irons footnote.
Right. So
that, there's a lot of other issues in this case with respect to 60B and everything that we'd have to get to before we'd ever get to something like that.
Right. Now, my second point was, I think, explains precisely why the court need not reach that issue under jurisdictional finality, right. Whether or not the decision was clearly enough articulated to be a precedential decision. It was a decision on the merits of the Foreign Sovereign Immunity Act.
We're not adjudicating today whether it should be precedent for other cases. What we're talking about in this and whether it's binding here, and I'm just not sure you want to get into or drag us toward the briar patch on that.
Then, Your Honor, I will exercise the wisdom to not make those arguments and simply refer the court to Judge Lamberth's decision on that point, should the court think it needs to reach the issue. But again, if the court needs to reach the issue, this is a case that I think would be very appropriate for en banc review, but you need not get there.
Okay. Make sure my colleagues don't have.
If you prevail on other grounds.
That's correct, Your Honor.
Yes. All right. Well, you're not waiving anything. Is all I'm saying.
No. If we lose on the other grounds and this court gets to the issue for the reasons set forth in the brief, the reasons set forth in Judge Randolph's dissent in the DeChapelle case, for the reasons set forth in Judge Lamberth's ruling, our view is that the proper interpretation of 1605A3 is the conclusion that Judge Lamberth has come to, and the conclusion reflected in the judgment of the DC Circuit in the Chabad case. And if any of the panel would like, I'm happy to go into those substantive issues. But Your Honor, Judge Rogers is exactly correct. We're not waiving those issues at all.
Okay. Let me make sure my colleagues don't have additional questions for you, Mr. Lieberman. Thank you.
Thank you, Your Honor.
For appellants, we'll give you 2 minutes back for rebuttal, and I know you were going to choose who's going to give the rebuttal.
Yes, thank you, Your Honor. Just to start, Mr. Lieberman said that this case would be analyzed as a practical concepts option 1 case, but whether it's Tenem challenging the finality of the judgment or otherwise, this is a practical concepts option 2 case because the entry of the 2010 default decision is the decision that took jurisdiction over the Russian Federation with any alleged sense of finality. Because that decision was a default, even though the Russian Federation did previously appear, that merely puts this case squarely in the Sudan v. Owens and line of cases, and the Bell v. Helicopter line of cases. The issue must be looked at because the Russian Federation was a sovereign with a de novo, non-discretionary level of review. And I'll say, even if not that, Mr. Lieberman and Chabad put in a case where a plaintiff under Rule 60B challenged its jurisdiction in its own case, and the court still looked at that case. I'm referring to the Lee Memorial case. And in that case, it wasn't finality. The jurisdictional question was reviewed again under a different standard, and one which we don't believe applies here, the arguable basis test. We believe it would be the Bell Helicopter test. But the notion that no party can ever challenge the 2010 decision on jurisdiction doesn't square with Lee or Bell.
Actually, that's not the argument being made. It's whether or not Tenet can challenge it through Rule 50B.
That is a secondary argument as far as
No, I mean, you're stating the statement very broadly, and that's not what we're discussing here. The chief judge's questions didn't imply that.
whenever 10M can challenge jurisdiction in this case, and I think it's clear from Vera and other cases that it is entitled to challenge subject matter jurisdiction. I just want to be clear that we disagree with Mr. Lieberman's argument that there's no way to revisit the 2010 decision taking.
Well, actually, he suggested, and in his brief, appellee suggests ways that this can come up.
Right. Okay. We think we do satisfy the standing test because, again, of the allegations of privity, that there are cases that hold that kind of relationship. I would not call 10M a legal representative, but that a privity relationship satisfies the legal representative prong of 60B. And so for that reason, 10M should be able to raise it in this context. And if not this context.
So you're not claiming tenant is a legal representative. You're not claiming tenant is a party.
10M is an entity alleged to be in privity. There are cases that hold that a privity relationship makes a party a legal representative. I don't want to necessarily use that word without noting that the definition of it is quite broad.
Okay, let me make sure my colleagues don't have additional questions for you, Ms. Konecki. Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Thank you, Your Honors.
This honorable court is now adjourned until Wednesday, October 13th at 9:30 a.m.